many experts mention that why economic strength being taken by basically dilution of these labor laws. Somehow we are trying to strengthen ourselves. We try to meet with basic standards of international labor organization, but somehow this is like a U-turn for us. And this particular situation, this particular scenario, not only create the problem those who are working, but also create those who are being terminated, and also those who are considered to be a migrants. So all of these three different situations we are basically stuck with in this particular pandemic situation. So when I talk about the person who are working, then there is a dilution, and I hope multiple news channel, multiple social media, yellow journalism cover on this particular point, that during this particular situation, during this particular lockdown, essential services related to that industry, uh, they just make long working hours to these workmen. And while considering, there are a lot many literature which is being cited by International Labor Convention and different other state, where it is being mentioned that the long working hours against basically create a problem and hurdle to the health of the workers. And nowadays, if you basically go through the different words terminology, then one of the main unit is like a healthcare unit. And if this is the situation where these workers work in long duration, then in that particular scenario, imagine how difficult for this medical industry, healthcare industry, in order to not only deal with the COVID situation, but also they need to deal with one more situation, that is a health hazardous from these workers. So my point over here is like when we describe this working, then also it is being very problematic situation for the workers who are working in different industries. Secondly, those who are being terminated because of closure, because of non-profit of the industry establishment, then they also face multiple things. They also face multiple problems. And third part is related to migrant labor. Though we have one legislation, interstate migrant labor, but to be very honest, this is being identified. It is not only being placed only as a law, but nowhere it is being implemented now. So these are certain problems, these are certain issues when we talk about the recent development with respect to labor law. Somehow we are going in a trying to meet with different on time payments. When we talk about, we do have now we have wage code. Before that we have payment of wages act, but everything during this particular time period we dilute in such a manner in order to get a good economic strength. But there are different mention that economic strength cannot be compromised with the health of the worker, with the safety of the worker. On these note, I believe as per recent development is concerned, we just take a one, this is like a one speed breaker as per recent development is concerned to our labor laws. And somehow some of the state create a U-turn by basically placing an ordinances, by diluting certain labor laws. And they mention about social distancing, where different countries, even some of these states, come up with shift hours of the workers. But as per industries is concerned, as per entrepreneurs are, as per businessmen are concerned, they are not being in profit. Undoubtedly, we know this particular aspect, but to be very honest, how we can manage the things is lie on one terminology, that is called industrial relation. Now, as far the introduction is concerned, I'm going to discuss first point is related to industrial relation, and this industrial relation is applicable all over the labor laws. Industrial relation is basically a healthy relation between employer and employee. Now, when we talk about employer undoubtedly think about profit and basically capitalization policies. But at the same time, when we talk about employees, we need to consider that employees at least get a proper wage, on time wage, and safety as well as working hour shift, proper rest, proper restroom, proper food and accommodation. All these things which we need to take care for the employees. Now, the role of the government is not to intervene in each and every aspect, but to be very honest, the role of the government is to create certain laws and they have to implement that law. So after implementing these laws, this create a boundary not only to the employer but also to the employees. And for the employer, it's like apart from profit, you need to take care of the employees, those who are working for your industry. So as per this particular situation is concerned, we do have different labor laws, and the implementation, at least in any scenario, in any situation, the implementation is one of the important factors. So let us discuss about the introduction of these recent amendments, what the recent amendment basically going on, and what will be the future course of recent amendments. So as per labor laws are concerned, labor law basically now divided into four categorization. First, we already adopted, it is related to Code on Wages 2019, and that compiled four different legislation. Payment of wages, one of the legislation is payment of wages. Second is Minimum Wage Act. Second is third is Equal Remuneration Act, and fourth is the fourth is related to the Payment of Bonus Act. All these act combined is basically now implement through wage code. Now, as far wage code is concerned, wage code undoubtedly define different terminology. Basically, they cover all the different definition which is there in different act into one. So that remove all the confusion and clarification. When we talk about employer, when we talk about employees, when we talk about establishment, all these things come under one ambit, one definition. So this wage code basically remove all the obstacles in terms of different definition, different terminologies. And second beautiful thing about this wage code is the floor wage. Before this, the term floor wage is concerned, floor rate is concerned, in Minimum Wages Act, all the state having a powers to decide whatever the minimum wage they wanted to enact in that particular state related to different industry establishments. So now, as per this floor rate is concerned, they create one single floor rate that is applicable to all these states. And after applicability of this floor rate, now it is open on all these states, whether they wanted to accept it at that particular point, at that level of floor rate, and they wanted to increase that amount. It's up to the state, but they cannot go less than that floor rate. So over here, they get autonomy to the state to decide the minimum wage, but they create one floor rate. So this is something which is like, as per recent amendment is concerned, this is something which is very good as per the wage is concerned, as per the minimum wage standard is concerned. Somehow we are trying to meet up with minimum wages. But as per International Labour Organization is concerned, there are different conventions where they mention that not only to basically go with minimum wage, we need to attain fair wage, and after living wage, and then fair wage. So these are certain things which we try to be on platform and on path, at least to cover this particular situation. Apart from that, there are some pending labor codes. So in order to compile different labor legislation into one, so that the terminology, because every act having a different terminologies, and sometimes that creates some confusion and problem even to the judiciary. There are multiple judgments related to that. So Occupational Safety and Health and Working Condition Code is also pending. This code basically provide safety, health and working condition for the employees and the workmen. Now, as per this code is concerned, this code is basically provide, not only provide safety, as well as this code also provides some insurance to these employees who are working in different industries and establishment. Third thing is the Industrial Relation Code, and this is somehow being challenged during this particular situation. This Industrial Relation Code basically a concatenation of three different acts: Industrial Dispute Act. Thirdly, it is a third act is like Industry Standing Order Act. Now, compilation of these three acts create Industrial Relation Code, and this is also pending. But in the present situation, these three acts also being challenged and taken to the consideration of dilution by different states. Fourth act is related to code on social security. This is one of the important component for these workmen, because these worker basically working in different organization. They require social security. If something happened to me, what happened afterward? Whether I'll get the wage, what insurance is being provided from the side of my employer? If something happened to me, then in that situation, what happened to my families? These code basically provide a compilation of each and everything. So these four code, as per this recent amendment, these are into the pipeline. One is already being accepted, that is the wage code on wage code 2019. All other are still pending, but these code gives a proper structure to the labor industry, so that at least employer and employee relationship cannot be harmed on any point of time. Now, one more code, Transgender Person Protection and Right Code 2019, is also enacted in the month of December 2019. This basically remove all the obstacles to the third gender and transgender person. And under this particular code, this create equal remuneration to this transgender person, where they already define who gender, and they also give that all sort of security, all sort of facility being provided to them as well, in terms of restroom, in terms of washrooms, everything they need to be provided, employer need to be provided, and ensure that there is a compliance officer in case of any problem, in case of any complaint, in case of any grievances. They, in this particular act, a grievance officer, a compliance officer is being allocated in order to basically provide help or to justice to that transgender. After that, in this present situation, we also see that the ESIC also create multiple to these employees, to these workmen. As per the contribution is concerned, we reduced the contribution in last year in contribution of 4.75 in terms of insurance, which need to be taken care by employer, and 1.75 need to be deducted from the wage of the employees. So this is reduced in 2019, and now it's like 3.25 is being shared from 0.75, only amount of 0.75 is being shared from the side of the employees. Now, why this reduction is being basically placed, and what is the help in terms of employees as well as the employer? Now, it's like sharing of burden. Now, contribution to this employee scheme of insurance corporation is basically reduce the burden not only to the employer but also to the employees. Now, employees can get additional salary, because initially it was like 1.75 they need to pay. Now it's like 0.75 they need to pay to the contribution to this ESIC fund. And this is like one of the social security, and ESIC unit is being established all over the India. If you check, there are different hospitals which basically provide hospitalization and medical facility to these insured person, even related to COVID as well. In this present situation, they already provide different isolation bed facility. And recently, in this particular COVID situation, they also mentioned one more thing. Those insured person who basically purchase the medicine from the dispensary of ESIC, in this particular situation, if they need to buy the medicine, they need not to go to the ESIC medical dispensary. Rather than that, they can take their own medicine and particular prescription, and whatever amount is being paid for that particular medicine, that can be reimbursed from ESIC. So these are the some facilities, recent changes being provided during in this COVID situation as well. Now, last part, as you see that for 3 months, not more than that, still it's applicable only for 3 months. This PF contribution, which is 12%, is reduced to 10%, so that the person, the employees get proper salary, they get proper money, as well as whatever the employer share, that also being reduced. So it's like supporting of the burden from the side of the government. So these are certain things which is recently changing in this present in this labor law. Now, what things are changed during this pandemic situation? Now, as per this particular pandemic situation, I cover only few points. There are numerous things being changed in this particular situation, and as per labor laws are concerned, undoubtedly there is so much dilution of the labor laws. Now, as there are these are certain major things which is very controversial in nature. Point number one is related to Factories Act. Now, as per Factories Act is concerned, Factories Act is provide safety, health safety, as well as the safety environment in particular industry and establishment. And this is being diluted during this particular COVID situation only on one point, that is called social distancing. Now, as per Factories Act is concerned, now working hours, there is one provision, section 51 of Factories Act, which says that there should be at least maximum 9 hours of working shift. But and as per weekly is concerned, it's like 48 hours. Most of these states, starting from state of Gujarat, starting from the state of Rajasthan, Himachal Pradesh, and Uttar Pradesh, they increase this working hours, daily working hours from 9 hours to 12 hours, and weekly is like 72 hours. Now, if we go to the initial document of International Labor Organization mentioned that there are, as per the impact report of working hours is concerned, the long working hours always create major health issues. And as per major health issues are concerned, that is also against a hindrance to the industry for working, and that creates multiple health issues. And in this present situation where people are basically suffering from different diseases, and major is like pandemic COVID situation, and if due to this long working hours, if anything happened to these workers, then what will be the consequence? Imagine the consequence. Already hospitals are being taking care of different things, and one more thing is being added. So these long working hours is like one of the worst situation which is being defended on the basis of social distancing, because most of the industries during this lockdown, during this pandemic situation, they are working with workforce of 33%, even to the essential commodities as well. So this long working hours create lot many problems to these laborers, and somehow as per Factories Act are concerned, they already restrict, and these different state, some state took help basically issue notification through section 5, which is related to emergency. And as they use this emergency situation, and they dilute that the working hours can be from 9 hours to 12 hours. And this is like extreme situation where they need to work weekly for 72 hours. And this is something which creates a lot many health issues. And some of the states basically taking up section 64 and 65, where it is being mentioned that the state government, whenever there is a requirement of essential commodities, they can change this working hours up to this 9 to 12. But as per this Factories Act is concerned, whatever working hours in India we used to follow is like extreme as per International Labor Organization. And during this particular situation, we make this extreme to the extremities. And 12 hours, and some of the state, one of the example is like state of Gujarat, where no overtiming is being placed from 9 hours to 12 hours. 9 hours is like a normal time period, and 12 hours, they mention that whatever amount is being paid to that particular workman, the same amount being paid till 12 hours. There is no means for these 3 hours, no overtime is being provided. And this scenario of overtime is not applicable to all of the state, but the state of Gujarat implement this particular situation. Now, second part, there are certain ordinances which dilute different acts. Now, as per Trade Union Act, the present situation where workers are basically demanding, and there is one national strike as well, where they are demanding that there should not be a dilution of this labor laws, because whatever we created through this labor law is beneficial and a balanced situation, not only for the employer but for the employees as well. so that at least they get proper safety, they get proper mindset to work, and whatever acts related to their families, they can be taken care by the social security code. But there are certain acts which is being diluted, and one of the major act is like trade union act, because certain ordinance mention that they will going to dilute this trade union act. And under the trade union act, the best feature of trade union act is the collective bargaining. Collective bargaining basically provide a strengthened situation for employees to bargain with the employer on certain terms and conditions, which is legalized and permissible by law. So if we dilute this trade union act, somehow the power of collective bargaining is not being with employees. So whatever condition, whatever means problem, whatever things they are facing, they cannot basically place before the employer. So the collective bargain, this is one of the important component of trade union, which is being diluted if that ordinance, if that particular changing in policy is being accepted. Second is like Industrial Dispute Act. When we talk about Industrial Dispute Act, then there is a procedure called retrenchment layoff. As you see the present situation, every time there is a news that this particular industry retrenched this number of employees. So this industrial, if we dilute this Industrial Dispute Act, then the major feature of this dilution is like industries will not, these establishment and industry will not take any permission from the government. As per law is concerned, if there are 100 employees working in one organization, they need to take permission for retrenchment, layoff, and closure down of the industry. But in this particular situation, if we dilute this particular Industrial Dispute Act, then in that particular scenario, to be very honest, from the side of the industrialists, they can take any action and they can avail the benefit of this situation. And even some of the state mentioned that they wanted to dilute this labor laws for 3 years. So this is like a worse situation if we consider in this particular situation is concerned. And if we mention that is strengthening the economy, there are multiple reports, multiple things mentioned by International Labour Organization that long working hours, dilution of these labor laws not going to benefit any of the economy, but also that creates a U-turn for that. So third part basically talk about the strengthening the structure of ESIC. Now presently ESIC authority is doing a wonderful things. They mentioned that whatever contribution of this ESI need to pay to this authority, that is being diluted. Now they mentioned that at least for means employee need to pay that amount to this authority within 15 days. Now they diluted for certain 45 days. So in order to strengthening the structure of this ESIC. Now ESIC also in this particular situation provide benefit to the COVID related patient, those who are insured under ESIC, so that those workers who are insured and basically exposed to this COVID situation, COVID-19, in that situation they get proper treatment under the hospital, which is being prescribed by this ESIC, proper medical facilities. And apart from that, they also diluted, as I already mentioned, they already diluted that whatever medical prescription is being provided from before lockdown, before this pandemic situation, and if any medicine is continued for that insured person, they can buy it from any medical store, keep that particular receipt to bill with that, and they can reimburse that particular, they can claim for the reimbursement. So ESIC is basically flexible in this particular present situation. Now most controversial and very close to this particular topic, there is one MHA order, Ministry of Home Affairs order, said that 29th of March, 27th of March, that whatever means that employer need to pay full wages to these employees. And during this particular situation is concerned, during this particular COVID is concerned, so they need to pay this particular amount. And apart from apart from this payment of wages, they also need not to terminate this due to this particular situation. And as far this particular point is concerned, there are so many cases filed not before to the high courts, but even to the Supreme Court. And yesterday, there is one order being passed on that particular point, and which I am going to discuss within 2 or 3 slides. So this MHA order, one side, this MHA order create means the Labor Ministry mentioned that this is like an advisory thing. Don't cut off any salary. Provide full wage to these employees in order to strengthen, um, and they should not enter into any mental issues because of not getting their salaries, and don't terminate them in this particular situation. On the other side, we need to understand that there should be a balance of economy from the side of the employer, and there should be a balance from the side of social security of these employees. So when we talk about the balance in that situation, the employer mentioned that if there is no work, means equal pay for equal work, no work no pay. So this is like a situation where employer is also mentioned, and they filed that particular case before the Supreme Court, and that particular case argued, or they mentioned only on 2 points. That particular situation, which is being which is being addressed as per section 10 subsection 2 of National Disaster Management Act is concerned, where where they cannot basically statute them that they need to provide that particular amount to these employees. And secondly, they mentioned that Article 14, right to equality, as well as Article 19(1)(g), where they cannot force them to provide salary when there is no work. In that particular situation, this MHA order being challenged, and which is being withdrawn. And yesterday, Supreme Court also mentioned on this particular viewpoint. There are not many questions, not many things thinking going inside the mind, whether employer is right, whether the employees are right. In that particular situation, Supreme Court also gave 50 days time period in order to negotiate. This is like one of the best thing, if employer and employees negotiate themselves and they come to a conclusion what we need to do for the payment of wages. And in this particular case laws are concerned, means there are multiple PILs is being filed, there are lot many writ petitions being filed from the side of the employer. And some of the employer in their prayer mention that they are ready to pay 50% of the amount, and 50% of the wage amount where there is no work. But at present, Supreme Court mentioned that the best thing, 50 days time period is being provided for the employers and employees. Different trade unions, they can basically negotiate on their own and come up with the conclusion. If they are not coming up with the conclusion, the same order mentioned that what will be the consequence. Then labor authorities, those who are mentioned in different act, when we talk about payment of wages in terms of the salary, we have local commissioners. Then they can approach to these authorities and look as per law that is being decided. So they give one more opportunities to the employer as well as to the employers to decide the matter on their own by negotiating on the concerns. And last part is like why I included this changes in labor law during this pandemic situation, interstate migrant workmen. This is like one of the act. Nowadays, we all heard this particular situation that where migrants are basically moving from one place to their hometown, where they're working to their hometowns, and there's means worse situation. They are walking on highways, and state governments are also arranging the buses and trains. But if we go through this particular act is concerned, we get all solutions where this particular act taking care not fully, but taking care of few things. That whenever there is whenever migrant means when migrant is being assigned to any industry and is being employed to any industry through a principal employer. Principal employer is like a company or industry or establishment or a factory. And if that person is being recruited by a contractor or through some agency, in that situation, all the means they need to register that particular migrant, and they need to provide proper housing accommodation, and if they are not providing accommodation in that situation, amount related to that, allowance related to that, they need to provide proper food, and for welfare, everything is covered under this Interstate Migrant Workman Act. But as per present situation is concerned, none of the state having a proper and appropriate data that how many migrants are working, and these employers and these work means these contractors do not have any data. And even some of the situation is like that, means that migrant worker is not aware who is the contractor through whom I get employed. So this is like a situation where the law is there as per words are concerned, as per spirit is concerned, there is no implementation of this particular law. So we required to make changes in this particular situation and make it more implemented, because this is like one of the warning in this particular present situation is concerned. Now, what are the ILO suggestion in terms of the changes of labor law? Now, first suggestion is related to the group of recovery. The group said that a recovery effort should stimulate the economy and employment using fiscal and monetary measures. Now, fiscal and monetary measure does not contain that it should basically ignore the rights of labor. So there is no point of dilution of labor law. If you really wanted to economically strengthen yourself in that situation, there are lot many things. And imagine a situation if long working hours, that creates unemployment, where there are 3 shifts of 8 hours as per Factories Act is concerned. Now 12 hours converted only to employment of a person. Now in that situation, that creates unemployment, and unemployment leads to many different problems. Secondly, it support the enterprises job and income through social protection. When we talk about this term social protection, then the person who is working in any industry, any establishment, any factory, then that this is the duty on the part of the employer to provide social security. If anything happened to me while working on that particular platform, while working on that particular industry, while working on that particular establishment, then who will take care? Then there are certain different laws in order. Employment Compensation Act is there, Employment Insurance Act is there. So these different acts create social security in the mind of the employees. Now, employment retention and a financial relief to these enterprises. Now, this is one of the important component, that employment retention means after this particular situation, there are lot many termination, lot different employees and workmen. So this particular situation create instability in economy, because once you get wages, you spend that wages, that is like an economic circle. So ILO suggestion is like that employment retention should be there. And apart from India, if I discuss the situation of different countries, then some countries not only provide means assistance directly to these person who are basically considered as below poverty line. Rather than that, they strengthen the employer, so that a strong industrial relation can be sustained. Because if means there are in UK there is one law where it is being mentioned clearly that if employer is going to retrench, they can approach to the government, and government provide means economic help to that particular employer, so that there should be a industrial relation can be happen between the employer and employee. But in India, the situation is like migrants are moving from one place to their home, and they don't have any faith on the industry, means on their employers, and that basically harm this industrial relation. A third point, which talk about the suggestion from the side of the International Labour Organization, workers need to be protected by strengthening occupational safety and safety measure at work by ensuring access to health care and paid leaves. Now, this is one of the important thing which is being diluted on these particular changes are concerned, because there are some situation, there are some safety measure which is not being taken care by these employers, and health measure means long working hours directly applicable on the health issues. So ILO suggests in this manner, so that a proper system can run with the wealth. As per welfare state is concerned, we don't need to ignore the labor rights. Now, how do the state government regulates this labor laws? So, as per state government is concerned, in India, the state government, if they are basically dilution, that is not a solution. Dilution create in long run create many problems. And as far this point is concerned, a state may regulate labor by passing its own law. So, as Professor Gururaj already discussed on this particular point, that labor laws are basically a concurrent subject where state can make there are certain specific area like mining where central only can lead that particular situation, but as per labor laws are concerned, that is in the concurrent list where union can make their own can make laws, central can make their own laws, and state can also uh, make certain changes and amendment as it is required in that particular state is concerned. But if they dilute and if there is a repugnancy, if there is something which is clashing from central law and the state law, in that particular situation, the central law prevail. And these are the points which state government need to be taken care while making any ordinances, while making any changes, and while making implementing any policies in even in this present situation. Now, second point is related to amending the central level labor law as it is applicable to state. Now, that is perfectly okay, but we cannot change whole of the act. We can basically change certain rules and regulation in it, which is being required in that particular state. Now, as per the central and states laws are incompatible, in that situation, central law prevail and state law will be what? Now, in this particular situation, there is a one example of Rajasthan in 2014 where they only dilute one of the provision which is being accepted. While making an acceptance of this procedure, they need to follow one thing. Means if there is a central law, if there is a state law, and there is a repugnancy, if there is any clash, in that situation, state can go for the assent of by the president. Once the state get the assent by president, in that situation, state can go and means. Apply that law in that particular jurisdiction in that particular state. So in 2014, Rajasthan come up with one law where they mentioned that in terms of retrenchment, instead of 100, if there is the industry which are having 300 employees, in that situation, they only need to take permission from the employer, means from the government, for doing retrenchment, because there is one retrenchment law is concerned where it has been clearly mentioned that if there are 100 employees working in that particular industry or establishment, then for retrenchment you need to take a proper course of action through government, but appropriate government. But over here, Rajasthan government mentioned that instead of 100, it's like 300, and that is being assent as per at that point of time there was a situation. So the president accept that particular point, and they basically give assent to the and if you check it is clearly that overtime is concerned, some state mention not required, as you can check in state of Gujarat. I'm just pointing this my arrow on that, not required. Now, in that particular situation, the changing increased from 9 hours to 12 hours in these particular states. And some of these states are not, even in their law, they actually mention that they are not going to pay as a overtime. Now, this is something which is basically, to be very honest, is like anti-labor law condition, because already Factories Act mentioned if you move from 9 hours to 12 hours, overtime need to be paid. They are working long hours and still they are not being paid as a overtime. This is something which is basically against the labor law. And as per period is concerned, as per section 5 is concerned, as per section 64, the maximum time period can be of 3 months. So as you check that the time period, almost every state implement except state of Haryana, it is like 3 month time period. They will go with that particular law. And this particular happened during this lockdown. and they are taking the point of into consideration that these changes we are doing in order to provide essential commodities to the public, and essential commodities being provided to these public, they require the means more working hours, because of the situation, migrant move from the place where they are working to their hometowns. So in this particular situation, they are not getting proper labor. And second thing, they mentioned that social distancing they need to follow within that industry or the establishment. So they took this into consideration, and changes being made from 48 working weekly hours to 72 hours, which is basically as per in the words of International Labour Organization standard is concerned, it's like very inhuman condition for these laborers. Now, if you check the different state, some state provide overtime to these members, and some state mention not required, means they not think that overtime is being provided as far this present situation is concerned. Now, what changes suggested by different state of Madhya Pradesh? I'm going to discuss two state, what changes being promulgated, what changes being uh, proposed by different states in order to dilution for the state the labor laws. Basically mentioned that they are having one act of industrial employment standing order act Pradesh Shram Kalyan Nidhi Adhiniyam 1972, where it is being specifically mentioned that there should be a worker of 50 or more worker, then this law is applicable. Now, as per standing order, I am after 2 or 3 slides, I am going to tell you what is the importance of this term standing order and what is this particular law. So this law is not being implemented on basically as per this particular law is concerned, that is implemented on 50 workers, but they basically diluted to 100 workforce. Now, as per 100 workmen is concerned, now 50 to 99 workmen, if there is an industry and establishment, this particular law is not being implemented. So this is like a dilution in that particular situation. Whatever condition they are basically enforced, the worker need to accept it. But if you government exempted all new factories from certain provision of Industrial Dispute Act. We know that Industrial Dispute Act provide a different provision with related to retrenchment that is not being applicable if we basically diluted this particular Industrial Dispute Act is concerned. But state of Madhya Pradesh mentioned that there are certain exemption in terms of retrenchment of the worker, closure of the workers, and layoff are concerned. But apart from that, if there is any other industrial dispute, then we cannot approach in a proper way as it is being means permissible as per law of Industrial Dispute Act is concerned. So in Madhya Pradesh government coming up with this particular order, basically diluting the labor laws, and new factories and new establishment basically exempt from these laws. And if it is being happen, then undoubtedly we take a U-turn, whatever we are going in a forward direction in order to attain the internet global standard of international organization, we are not able to get approach to that. As per state of UP, Uttar Pradesh is concerned, this particular state ordinance is being in news throughout the time, and there are certain provision which they basically taken back. And as per wages, these are something which they basically pass in the ordinance as per wages concern, as per health and safety, working hours. They mentioned that it should not go beyond 12 hours, but 12 hours is like an inhuman condition as per International Labor Organization is concerned. They also mentioned that whatever Bonded Labor Act is there, they will implement that, and any law related to women and children. But as you go through this particular ordinance is concerned, that this ordinance basically diluting, not talk about any social security. Social security in terms of social security, PF means Provident Fund. We do have one act related to Provident Fund. We do have act related to this insurance compensation. State of UP ordinance is silent on that particular provision. They also not talk about means diluting Industrial Dispute Act entirely. Apart from that, the Trade Union Act, where the collective bargain is not there, means whatever employer wants to provide without being bargained on the front side. And last part is like they also apply this particular ordinance for 3 years. Imagine a situation for 3 years in order, because they wanted to strengthen the economic structure. And while diluting the labor legislation is not only the solution, as per this, as per economists are concerned, as per labor experts are concerned. Now, there are few judgments. Already I mentioned about the amateur order, which is basically being withdraw, and which is being into consideration in different courts. Now, I'll just go through these four judgments. There are multiple judgments in this particular present situation, and these are the four judgments which provide you a very good and clear-cut examples of different things. Now, first judgment, Align Component versus Private Limited versus Union of India. This is a Bombay High Court judgment. Now, let me just give you a brief background. This case was filed in the month of April, and during the same time, one more case, that is Ficus Pax Private Limited, second case, is filed in Supreme Court on the same point, that full wage need to be paid to the employees. But Bombay High Court mentioned that already this case is being pending on that same duration of time. I think the date of Supreme Court judgment was 27th of April, and during that point of time, the Bombay High Court mentioned that whatever Supreme Court will decide, we will consider the same. And apart from that, one major point is being disclosed by Bombay High Court judgment as per para number 8 is concerned. They mentioned that during this particular time period, government assigned certain zone into different colors. Green zone where the industrial activities being permissible, orange zone where some industries activities is permissible, and with certain limited workforce is concerned. Now, before lockdown, if employee basically move from the place where that industry is being worked to their hometowns, and that hometown where they are is like a red zone, and they are not allowed to go out from the boundaries, and most of the states seal their boundaries. In that situation, that particular establishment, that particular industry getting permission from the government to run, and these employees are not in that particular area. Now, whether they have means as per amateur order is concerned, we need to provide full wages. But Bombay High Court mentioned very beautifully that if employee move or workmen move without taking permission from the employer, as per standing order, as per the contract of services mentioned, that if you move from one place to another, you need to inform to the employer and take permission from the employer. And if that employee not take any permission from the employer, then they have proper right, as per labor laws are concerned, to deduct the salaries, to deduct the wage as per permissible deductions are concerned, as per payment of wages. High Court undoubtedly mentioned that whatever Supreme Court will decide as per full wage payment or order, that is with the Supreme Court. But where the green area where that industry get authorized permission from the government, in that particular situation they can run. And if an employee is not able to turn up for the job because he is being basically restricted in that area, which is like a red zone, in that situation, this particular judgment mentioned that employer has a legitimate right to deduct that particular amount. Second judgment, and yesterday itself, the one of the order is being pronounced by this court, is related to Ficus Pax Private Limited versus Union of India. This case is basically filed by means this is like a concatenation of different writ petitions and PILs, and they basically these employer is being is challenged the amateur order that if there is no work, why we need to pay whole of the amount, where some of the writ petition employer mentioned that they are ready to pay 50% amount, and on 27th of April, the government mentioned on 27th of April, on 27th of May, government mentioned that it's that whatever means whatever employer need to pay that amount, and uh, employer move to the court on certain points, article there is a violation, gross violation of article 14 and article 191G. And they also mentioned that the section 10 subsection 2 of disaster management cannot compel to pay that amount, where center mentioned that this order being passed in a proper way, and this order need to be implemented in a true sense. And yesterday the order pronounced in such a manner that Supreme Court itself that say that it's on employer and employees, and they give 50 days time period to negotiate on these payment, and whatever they decide, different industry decide, trade union decide while negotiating different conditions. That is like a best way which Supreme Court basically placing. And this particular, the next date of this particular case is in the month of last week of July. And they mentioned one more thing, that there should not be any coercive action being taken from for the employer. If employer not pay any amount, because MHA order mentioned that you need to pay that particular amount, and on the same part, Supreme Court mentioned that there should not be any coercive action need to be taken, any penal consequences need to be taken for these employers. So this is like one of the means balanced sort of situation, where somehow employer getting undoubtedly a benefit, and in true sense, if negotiation go in a proper way, maybe a proper solution can become. Because as we know this particular point, that if employer means if court or any authority decide this particular point, then somehow this is against some of the employees or some of the employers. And if anything against pronounced, then industry relation is one of the means problematic situation. And third case is related to interstate migrants are concerned, and I already told you that we have one act related to that. And in this particular public interest litigation, um, one point is being mentioned, that there should be proper kindness and humanity for from transporting or from taking this migrant labor from one place to their hometowns. And apart from that, this case also mentioned that there should not be a circulation of fake news through media, through social media, through any yellow journalism, through any post or status, that there should not be any fake news. And because of this fake news, these migrants are moving from one place to another place. And this is being mentioned not only by in this particular that you need to take care of fake news. Right now there is a plethora of fake news going on in social media, and means social media, even in the yellow journalism. So these are certain situations which we need to take care. And in this particular judgment, the guidelines in order to kindness and humanity and proper food, drinking water is being provided to these migrants, not only the transportation facility. And just because of this reason, the different state government approached to the center, that they wanted to send back the migrants to their homes. And just because of that reason, railways and buses being deployed in order to take them back to their home areas. And lastly, in Ray problem and miseries of migrant labor. And on 9th June, one more additional advisory being issued, that those migrants who are basically suffering due to this particular situation, they can be they have to be taken back to their area, to their hometowns. And they should not be, at least means they should not be taken any amount from them, and proper food and every facility should be provided. The basic necessity should be taken care. And if there is some relief rooms and restrooms being created for them. So this things which is being discussed, and different state is being provided different data, that how many means how many migrants being registered, how many being means sent back to their home. So these all things being discussed in this particular judgment is concerned. Now, as far the conclusion of my topic is concerned, there are different things going on in this particular present situation. I must not say that this development, whatever we achieve at the time of accept means in enacting that wage code, and we are on the verge to accept different three different codes as well. Now this is like a U-turn, because somehow internationally we represent through international labor organization, nationally from different act and constitutional. But this dilution comes in the state, which basically weaken the structure of industrial relation, means employer-employee relation, and there should be a proper balance of economy and social security of the worker while deciding any law related to labor. We need not to take care only one aspect, that we need to strengthen the economy. We also need to take care the social security of these workers. When we talk about the social securities, undoubtedly this also give strength into the economy, because right now we are going in a situation where health is one of the important component. Health sector is one of the important component. If we dilute this labor law, imagine the condition where workers are working for 12 hours, and if something happened to them again, this is the burden on the states as well. So while deciding any means ordinance, while deciding any changes in the policy, we need to take care of balanced situation, economy and social security, as well as the welfare of employees are concerned, welfare of the workers are concerned, welfare of the migrants are concerned. Secondly, the long working hours should not be considered in any manner, because this is not going to strengthen the economy, because as we already know, this particular situation where unemployment is one of the restriction and hindrance of its economic structure, and long working hours somehow basically reducing the job capacity in labor market. Third thing is like a dilution of labor law create many problems in long run. Now, when we think about short run is like means there is no time frame of short run, but this particular present situation somehow diluting many things. But when we talk about long run, in that situation, we are trying to basically strengthening our labor law as per international global standards are concerned, and still we are struggling a lot. And this particular situation basically just give a u-turn. And if we talk about in long run, undoubtedly in global market, we basically not represent in a very good manner. And that's why recently, 2 weeks before international labor, when trade union approaches to the international labor organization, national trade union approaches to the international labor organization forum, and international labor organization mentioned to the labor ministry, and labor minister Santosh Gangwar mentioned that the dilution of labor law is being done in a manner which is basically against the welfare of these labor. Last point is like government should support economically to the employers in order to stop termination and retrenchment. This is like a situation I know in India. It's like there is a lot much workforce, and there is a lot many laborers, migrants. But in this particular structure, the other countries structurized in one way that they somehow support the employer, and through employer they are basically providing the wages if employer is not able to do that. And that creates somehow strengthening industrial relation. Once the situation get normal or somehow better, in that situation, at least these employees or these workmen can back to their work. This is the thinking, this is the objective of UK, this is the objective of different countries. And I think we should also, this is like an opinion. I know it's very easy to mention opinions, but as per the literature which I reviewed, I researched, I find that one of the things which is being supported from the side of the government, and undoubtedly government as per the package is concerned, mentioned that they are going to strengthen MSMEs and different industries. But one thing which is being missed, which is being structurized, that it's like direct benefit. It's not like through employer, because the industrial relation is one of the important component which I believe which different labor experts believe in order to strengthen a good workforce and a good outcome in order to be the production for the country is concerned. So this is all about the presentation on recent amendment, which I included from the back of situation of the pandemic, during the situation of the pandemic, as well as I discussed certain judgments where Bombay High Court judgment is also one of the important factor which mention one of the key point that if employee means at that point of time there was different zones, and if employee without any workman, without taking any permission, went to their home, in that situation they have a legitimate right to deduct that particular wage. So over to you, Sagar. Thank you so much, everyone, for this presentation and listening to me.
Yeah, thank you very much, Mr. Arpit.
Oh, welcome, Sagar. Please tell me.
Now we are having certain questions from the
Oh, great.
participants.
Yes, please.
Yeah, just a minute.
Yeah.
If employer belong to one state and laborer belong to another, and there is
Yes.
a dispute between them, then what procedure should be followed, and which court would have the jurisdiction?
Okay. So as per jurisdiction is concerned, where the industry is there, means where that industry and establishment, that is like a jurisdiction. And I already mentioned that if worker move to their hometown without taking permission, and sometimes there is a situation where employer not responded back if they even place that particular permission. So in that manner, as far jurisdiction is concerned, the basic jurisdiction where they need to file is the place where they are working. Any other
Hello.
questions, Sagar? Yes, please.
Yes. So, what procedure is to be followed in that scenario? Like, if an employer belongs to one state and laborer belongs to another state, and there's a dispute, then what the procedure is to be followed?
In that situation, means that labor approach to the labor court in that particular jurisdiction, and through trade union that labor can also be represented, and if that labor is having a certain individual dispute, then they can approach to the labor court. Before that, they approach to this labor commissioner, make a representation before the labor commissioner. Whatever reply labor commissioner provide, then they can, if that laborer is not satisfied, then they can approach to the labor court. So this procedure which labor need to follow.
Yes, very well. So, I do not think there's another question. As such, I cannot see it.
Okay.
Apart from this, if you want to like share your views on the present current situation with
Okay.
regard to the amendments that are undertaken and the
Mhm.
developments that have happened. So, can we have that
Yeah, please. Yes. So as
in
per
brief?
yes, very brief. And if Sagar, if you allow me, okay. So in that situation, as per the development is concerned, development of labor laws are concerned, undoubtedly this present situation is very means we never face this particular situation. Whatever recourse government is having, they are basically doing their level best. They are trying to doing their level best. As per this dilution is concerned from these different states, I don't think so this is like a development scenario. This is also like a adverse situation. And as per advancement is concerned, as per advancement of labor laws are concerned, this labor law basically somehow restrict the employer. So some benefits is being shared to the employees, those who are working as a workforce. So as this particular situation is concerned, long working hours, undoubtedly social distancing is one of the important component in that. But rather than that, some countries, what I research and getting that literature is like there should be a different of shifting of work. Means if 33% is being employed, if that industry is working 12 hours a day, in that situation it can go to different shifts. And as per international labor organization conventions are concerned, 5 to 7 hour shift where a skilled worker or semi-skilled worker, they can give their maximum output. And if this shifting is being possible, different shift is being possible, then I think this is like a best solution in this present situation is concerned. And dilution is, as per different amendments are concerned, undoubtedly it is like means the different codes are in standstill conditions. So once they get implemented, and because that's a central legislation, I don't think so that the state have to accept it, and that also going to strengthen the strengthen the of these laborers. So present amendments undoubtedly during this pandemic situation is concerned, undoubtedly very harsh for these laborers. And as per interstate migrant law we have, that is not being taken care since the inception of that particular act is concerned. And just because of this situation, migrants are the one who suffered a lot. So these are some views of mine, and opinion is like I already mentioned in my conclusion that if you really wanted to strengthen labor laws, then there should be good industrial relationship, and that cannot be possible for dilution of labor laws.
Yeah, so actually, you have included and tried to touch upon all the aspects, including the statutes and the case law. So that is wonderful.
Thank
And
you.
yeah, so thank you very much, Mr. Arpit. It was wonderful to have you at Legal Savior, and I hope this presentation was very detailed and with a different angle one could study the subject. So
Definitely.
I thank all the participants that they have also joined us today in part two for the labor law part two series. I would also like to convey to all connected right now that from 15, that is Monday, we are going to have forensic marathon web series for constantly 2 weeks on various branches of forensic science and law. So do kindly join in that series too. It would be entertaining, it would be knowledge sharing, and it would be an opportunity to listen from various speakers from around the world. So do join us. And on that note, we would conclude, and I would request Mr. Arpit to stay connected for a while.
Okay.
Yeah. So thank you all.
Thank you so much, everyone.
Yeah. I can just see a question coming up.
Yes, please,
As in
please tell
India,
me.
yeah, you are convenient with time, I think. Okay.
Yes. Please tell me.
Oh, yeah. As in India, there are n number of laborers who work on day-to-day basis. So, in case of any medical emergency, is there any law or act which might help them? Will these day-to-day workers come under state or center?
Okay, so this question is divided into two components. First of all, I'm going to answer this labor belongs to state or central. So if they are working on daily-to-day basis, so if they are working for that is the central legislation, which is already being defined in union list. So first we need to identify which sort of industry. If it is in central head, then the central will govern, and if it is in state head, then state laws will govern that particular labor. So as if there is any medical, then we already I cover in my presentation as well that there is a employee scheme insurance corporation, ESIC, where this is a duty of the employer to register the employee once that person get enrolled. So this ESI will provide benefit in terms of medical, and this is one of the thing. But as per day to day, as you mentioned, the day to day workers is concerned, so it's like a contractual worker. So this, as per Contract Labor Act 1970 is concerned, this is the primary duty of the person recruit or employed. For example, if principal employer employed that particular day-to-day worker or labor, in that situation, that is being taken care by this that principal employer. And if it is being assigned employed through some industry or agency, in that situation, that is being taken care by this contractor or agency. So we do have law, first of all, as you mentioned, day to day. Then it's like the Contract Labor Act 1970, where principal employer as well as the person who employed through contractor is being taken care of that particular worker health and safety is concerned. Over to you,
Yeah,
Sagar.
definitely. Yeah. So it answers another question which was raised, that importance of the laborers in the factory. It covers this too.
Yes,
And
yes, yes.
now, yeah. So I hope that every query is answered,
Mhm.
and that too with the backing of case laws, statute, and all other aspects which are necessary. So thank you very much all, and thank you, Mr. Arpit. You stay connected for a while, and I
Sure.
would request all the participants that the session is complete and we would conclude, and do join us from Monday. Thank you all for joining us. Hope it was informative and knowledgeable too. Thank you.
Thank you so much.